Well, hello everyone. Welcome to Planning Shorts. Thank you very much for everyone for joining us. This is the 6th episode of Planning Shorts, and the title of today's webinar is What's New with Heritage Assets? So my name is Killian Garvey. I'm a barrister from King's Chambers. I'm joined by 4 of our regular panellists, all fantastic barristers in their own right. So if I can introduce them all, to begin with, Matthew.
Hi everybody, I'm a barrister in Landmark Chambers, Matthew Fraser, and glad to be here today.
Matthew, can you tell us what your favourite heritage asset in England and Wales is, given that that's the subject of today's webinar?
I can indeed. So if I stop my video for a moment, you will see the zebra crossing near Abbey Road Studios, which has been listed as a heritage asset since 2010. It was made famous on the cover of the Beatles' 1969 album, Abbey Road. It's a very unusual front cover for an album because it doesn't have the name of the band or the name of the album on it. It just speaks for itself. And it also gave rise to a very strange conspiracy theory that Paul McCartney was in fact dead because he was the only Beatle shown without shoes on.
That's been a popular quiz question I found during lockdown. which Beatle wasn't wearing shoes? Right, next, Tora, would you like to introduce yourself?
Hi, Killian. Yeah, my name's Victoria Hutton, barrister at 39 Essex Chambers. And my favourite heritage asset, if I just stop my video, is this. Now, one of the best things about being a planning barrister is you get to see things and meet people that you wouldn't otherwise see or meet. And this is one of mine. It's called Blick Mead. It's a Mesolithic archaeological site just outside of the Stonehenge World Heritage Site. And I represent a consortium of archaeologists who are opposed to the Stonehenge tunnel, and we're concerned about a number of heritage issues, but this is one in particular. And the thing that makes this site so exciting is that its water table means that organic matter from the Mesolithic era has been preserved. So the archaeologists are able to pull out, for example, pollen, teeth, and also discover hoof prints from 5 to 8,000 BC. So to put that in context, that is older than Stonehenge is to us. So hugely exciting and wholly dependent on the water table, which is something that we are concerned about the effects of the tunnel on. So that's my pick for today.
Thank you. And Ashley, would you like to introduce yourself?
Yes, thank you, Killian. Good afternoon. I'm Ashley Bowes. I'm a barrister at Cornerstone Barristers. And what I've chosen is this, which is Waterloo Bridge, a Grade 2 star listed building. And I've chosen it for a number of reasons. First of all, it's a great modernist design. Secondly, I walk across it in normal times anyway, twice daily. Thirdly, it's got the best view, in my opinion, of the London skyline, the House of Parliament to your left if you're heading into London, and then the city to your right, especially at night. And finally, it's a very interesting historical twist to it that was discovered more recently, is that it began construction during before the war, and it was completed afterwards, during and afterwards. And the construction team during the war was a largely, almost exclusively female workforce, and this was recognised in more recent times, which led to its upgrading from Grade 2 to Grade 2 star in 2015. So for all those reasons, my favourite heritage asset is Waterloo Bridge.
Thank you. And finally, Thea.
Hello, hi, I'm Theo Osmond-Smith. I'm a barrister from number 5 Chambers. Apologies to those who can't see the heritage assets that are showing on our screens when we disappear, but I'm going to show my chosen asset now, just in case there are people who can see. And I have chosen Ludlow Castle, which is a Grade 1 listed building in South Shropshire. And I've been visiting that castle since I was a little girl. And I've been taking my own daughter since she was a little girl as well. And they do wonderful outdoor performances of Shakespeare within the castle grounds most summers, unfortunately not this summer. But the interesting fact that I have about Ludlow Castle is people probably know Henry VIII. He's quite a famous king, but he had an older brother, and his older brother was called Arthur, and he was obviously going to be king upon the death of Henry VII. And he was married at age 15 to Catherine of Aragon. Bit weird, you recognise her name because she was also Henry VIII's first wife. Little bit incestuous. But in any event, not long after the marriage, they moved into Ludlow Castle. They were going to make it a home. But shortly after they moved in, Catherine and Arthur were afflicted by an unknown illness, which has been characterised as a malign vapour which proceeded from the air. And Arthur unfortunately died on the 2nd of April, 1502, 6 months before his 16th birthday. So that's how we came to have Henry VIII as our king and not Arthur.
Right, well, thank you very much. Last week I did the episode from Alton Towers, so this week this is a Zoom background. I'm not standing in front of Clifford's Tower in York. Right, so today's episode is what's new with heritage assets. So Thea, if we can start with you, and just before I ask you to talk to us about a recent judgment from the Supreme Court, I should say to everyone we've got a chat function. And also a Q&A function. So please do ask us questions as we go. Feel free as well to share what you think your favourite heritage asset is as well. So Thea, recently the Supreme Court gave judgment in a judgment called Dill against the Secretary of State concerning whether an urn was a building. Can you talk us through the judgment?
Yeah, sure. And I'm sure that actually most people who have logged in probably have an interest in heritage and will have heard of this case, but I'll give you the facts briefly. Essentially, it concerned a pair of 18th century lead urns, and they'd been around the block a bit. And in 1973, they found themselves placed on either side of a path at Idleycote House in Stratford upon Avon. Now, the urns were listed in 1985 and Mr. Dill acquired them together with the house in 1993, and it appears that he didn't know that they were listed, and nor did his father before him. The urns were sold at auction in 2009 and they left the UK and they've not been seen since. Anyway, 5 or 6 years later, the local planning authority wrote to Mr. Dill and threatened enforcement action because listed building consent had been required to remove the urns. Now, eventually there was an enforcement notice requiring the reinstatement of the urns, and Mr. Dill appealed because he considered that they were not a listed building. But the inspector considered that it was not actually open to him to interfere with the listing, and so Mr. Dill lost. Now, the High Court agreed with the inspector, and so did the Court of Appeal. But Mr. Dill and Richard Harwood QC were not to be deterred, and so they went off to the Supreme Court to see what they thought about it. Now, there were two questions for the court. The first was whether an inspector considering an appeal under Section 20 or Section 39 of the Listed Buildings Act could consider whether or not something was in fact a building. And if so, what were the relevant criteria for doing so? Now, Lord Calmer answered the first question really shortly and said, yes, it was open for an inspector to consider whether or not something enforced against and that was listed was in fact a building. In respect to the second question, what is a building? The court noticed a disturbing lack of clarity in what a building was. I mean, it seems pretty obvious to me. I would say urns, building, nope, but really not that straightforward. But the court did essentially endorse the criteria in the Skerritt's case, in which a substantial marquee was erected and retained on site between February and October every year, and that was considered by a planning inspector to be a building. So the three factors to have regard to are size, permanence, and the degree of physical attachment to the land. Now, the court did decline to arrive at a view on how those tests applied in this case, because essentially that's a judgment based on all the evidence which is best dealt with by a planning inspector. However, the court did recognise that poor Mr. Dill had been denied a clear ruling on the issue for 5 years and gave a pretty clear steer that it would not be expedient for the local planning authority to continue with this particular enforcement action. And as I understand it, the enforcement notice has now been withdrawn. In terms of wider ramifications of the case, I don't think it is going to have wide ramifications, or as the brilliant Gail Stoughton puts it, it won't be a bonfire of list entries, because so few things on the list aren't buildings. But I actually do think that Matthew's favourite asset is one of those things that might be a little bit susceptible following the judgment by the Supreme Court on this matter.
Well, naturally, that brings you in, Matthew. Well, Matthew, what do you think the practical implications of the judgment going forward are?
Well, the devastating loss of my favourite heritage asset is probably the most important implication. But I think it does have two types of implication. The first is as to the procedure for determining whether a listed building is actually a building, and secondly, as to the substance. So starting with the procedure, we know from DIL that it's now open to inspectors in listed building appeals, or indeed a criminal court considering a prosecution, to question the listing. And in my view, it also seems to apply to any context where a listed building is an issue. So a planning application being determined by a local planning authority. A local planning authority could, in my view, consider the question of whether the building should be, whether the listed building is in fact a building. And similarly, on a Section 78 planning appeal, the same would apply. And I think another procedural implication is, what are the consequences in terms of such a determination? Is the Secretary of State obliged to review the list? And if it does, what if it comes up with a different conclusion? And at the moment, the Historic England guidance on removing a building from the list, unsurprisingly, doesn't deal with this particular situation. In terms of the substance, I do agree, I think, with Thea that they are relatively limited. I don't think there's a huge number of listed buildings out there that are suddenly going to get taken off the list. Although there are, of course, some, I can think of a number of potential contenders, lots of listed structures that might not in fact be buildings, in addition to my zebra crossing, things like listed gravestones, sculptures, boundary markers. There's even a listed telephone kiosk somewhere. So that sort of thing might be quite interesting to see what the implications are for that.
Right. Well, so folks, when we talk about heritage assets, oftentimes in the planning world, we're concerned with heritage harm. But there's been a suite of case law in the last few years dealing with, well, what happens when you have heritage harm and you also have heritage benefit, and how do they relate to one another? So Tora, perhaps how you can talk about this issue in the context of the Court of Appeal judgment in Palmer?
Yeah, of course, Killian. So this is the case of Palmer and Herefordshire Council. It's a well-established judgment. It was handed down, I think, November 2016. And it concerned a planning permission for broiler units close to a former train station, which was Grade 2 listed, and the former train station was now in residential use as an agricultural dwelling. Now, the claimant submitted that the local planning authority had failed to consider certain types of harm to the setting of the listed building. So they were odour and noise. And the court, considering that argument, helpfully reiterated some of the principles which the courts had already established. So it stated that the concept of preserving the building or its setting means doing no harm. Harm could include non-visual effects, so noise and smell. The degree of harm is a matter of planning judgment, but once you have harm, that has to be given considerable weight in the planning balance. Looking at the particular officer's report there, it found no error of law. And one of the interesting statements that the court made was that where a proposed development would affect a listed building or its setting in different ways, so some positive and some negative, the decision maker could conclude there's no overall adverse effect on the listed building or its setting. Now, that's often quoted, that passage of Lewison, Lord Justice Lewison's judgment, but I think there's a strong argument for saying that was an obiter statement. I didn't form part of the ratio of the case. And so technically, moving forward out of this case, and we're going to come on to others, that the issue is up for grabs and up for argument by people like ourselves.
Well, Ashley, in respect to this notion of balancing harm and benefit, how have the court said this relates to whether paragraphs in the MPPF are engaged?
Yes, well, I think this is the particular case I have in mind follows very much on from what Tora has just told us about Palmer and how it's been interpreted. And the case I want to draw your attention to is Safe Rottingdean against Brighton and Hove City Council. And this was a proposal for a housing scheme on a former school within a conservation area and within the setting of a listed building. And within this case, dismissing the claim, Mr. Justice Ousley says you have to approach Section 66, the duty to preserve the setting and significance of listed buildings holistically. And he says, well, that's to say that you have to look at the ways in which a scheme will affect the listed building and come to an overall judgment as to whether the setting and the listed building is preserved. And that leads to the conclusion, the natural consequence of that is that you can have a situation where there is harm to the listed building in heritage terms, but overall there's no breach of Section 66 because the benefits in heritage terms outweigh the harm. But he said that does not mean that the harm is ignored, and that as soon as you have any level of harm to the heritage significance of a listed building, that engages the relevant paragraphs of the MPPF. Now, that's all based on a reading of Palmer, with which I don't agree, and which Tora flagged up and highlighted. And what Lord Justice Lewison said, para 29 in Palmer, is probably just worth bearing in mind. He says, where a proposal would affect a listed building or its setting in different ways, some positive, some negative, that the decision maker may legitimately conclude that although each of the effects has an impact, taken together there is no overall adverse effect on the listed building or its setting. And this is where I think it's really important that you have to read cases in the context of the facts that are before the court. Because what happened in Palmer was that there was in fact no heritage harm. The references to harm in the officer's report were to the situation before the mitigation effects had been put into place. And it was the planning judgment of the council that when the mitigation measures were put into place in effect, they would avoid any level of heritage harm. So what Palmer is saying, either you can say, well, what Lord Justice Lewison says at 29 is obiter because it didn't arise on the facts of that case. But I think when you read that paragraph as a whole, the immediately preceding sentence, it's clear that when he talks about positive aspects, he's talking about the mitigation effects. And my very strong view is that Palmer is not authority for the proposition that where there is residual harm, even after you've applied the mitigation measures, you can then legitimately find no breach of Section 66 of the Primary Act. And why I think that's the case is because you could come to a situation where paragraph 196 of the framework is engaged because you have less than substantial harm to the listed building. But because there are heritage benefits which outweigh that less than substantial harm, you perform the paragraph 196 balance without giving considerable importance and weight to the harm because Section 66 isn't breached. And that could lead to an odd situation where the framework is telling you you must give great weight to any level of harm. But the statute says, if Mr. Justice Ouseley is right, that it's not breached even where there is a level of harm. And I don't think that's quite right. And this is why it's perhaps crying out for resolution by the Court of Appeal again.
Well, Matthew, perhaps I can bring you in on this question. Do you see a tension in the law about what one does when you've got heritage harm and heritage benefit? And I mean, is the law settled on this?
I think it's definitely a tension. I mean, the arguments that Ashley was just talking about shows that this is a highly contentious issue, and Ashley's just explained why arguably Save Rottingdean is wrong. But there's been a subsequent case, City and Country Bramshill Limited against the Secretary of State, which considers Save Rottingdean and concludes that it's correct. However, permission to appeal to the Court of Appeal has been granted in relation to City and Country Bramshill. So hopefully that will give the Court of Appeal the opportunity to undertake a comprehensive review of how all of these different policy tests relate, because I think it's really important to do this, and I think Mr. Justice Ouseley does do this in Save Rottingdean, is to distinguish between how to apply local plan policies, how to apply the statutory tests, and how to apply the MPPF, because I think people quite often get confused between the three of them. And I think it'd be really interesting to see how the Court of Appeal resolves this distinction between, on the one hand, mitigation measures which negate an adverse effect which would otherwise arise, and then on the other hand, separate heritage benefits, which don't remove or eliminate the adverse effect, but simply compensate for it in some kind of balancing exercise.
Okay. Okay. Well, Ashley, perhaps we can talk about a very recent judgment of the Court of Appeal, which is the Liverpool City Council and Redrow Homes issue, which considered an application of the Listed Building Act. Can you talk to us about what this judgment is?
Yes, absolutely. So this concerns two permissions that were issued for residential development on the City Council's own land. And the issue that arose in this case, one of several, but the issue that led to the quashing, was that the internal heritage consultant said that there are, quote, strong objections, conservation objections to the proposal to erect 3 houses within the grounds of the Grade 2 listed building. And he or she advised that there was less than substantial harm. So that was what the internal consultee was saying. Then the officer's report to committee didn't mention this response, but did say there was less than substantial harm, but advised that it was outweighed by the public benefits of the scheme. And the consultee response that there were strong conservation objections wasn't raised at the planning committee meeting either, and that point was expressly confirmed to the court. And what the Court of Appeal decided, Lord Justice Limblom giving the leading judgment, was that that failure to draw to the committee's attention the, quote, strong conservation objections was enough to displace the presumption that the Section 66 duty had been properly performed, because the report quoted the Section 66 of the Act. And those of us remember Jones and Mordew in the Court of Appeal tell us that where a decision maker quotes the statutory duty, or they quote one of the bundle of NPPF paragraphs that refer to heritage assets, the presumption is that they have properly applied the statutory duty, unless there are, quotes, positive indications to the contrary. And Lord Justice Limblom said, well, this is a situation where there is a positive indication to the contrary, because there was an internal consultee response saying there were strong heritage objections, and you didn't report that to the planning committee. And that was sufficient to displace the presumption. And interestingly, also, just straying away from heritage, we see Lord Justice Limblom using Osmund-Smith and the formulation of the law on material considerations, where he was overturned in the Supreme Court earlier this year, to garner support for his argument, effectively, that notwithstanding this was a heritage omission, it was also a failure to have regard to a relevant consideration, in the sense that this was something that was so obviously material that a failure to give direct consideration to it was an error of law. And the final thing I'd just like to say about the case generally is that I think it calls into question the judgment with respect to Mrs. Justice Andrews in Pagham Parish Council and Arran District Council. Now, I disclosed this was a failure of mine. So with that caveat, I will just explain why. Because in that case, it wasn't the internal heritage consultee who said there was harm. It was the applicant for planning permission's own consultant who said there was heritage harm, but the officer's report didn't mention it. And the judge in that case decided that that was an omission which shouldn't lead to a quashing, because it was the decision of the planning authority, ultimately, whether there was harm. And it wasn't really to do with the individual expert consultants. And I think that the Liverpool City Council case in this respect perhaps restores a more orthodox approach, that where the NPPF tells you to take into account and solicit expert opinion, you have to put that before the decision maker. So in that respect, I think the judgment is a restoration of orthodoxy and correct.
Thanks a lot, Ashley. I should say there's a heat debate that started in respect to whether Abbey Road should be listed. And it's just occurred to me that we shared the photograph of Abbey Road, which has the Beatles crossing it. There's also a famous album cover from the Red Hot Chili Peppers where they walk across it naked, save for some well-placed socks. So for professional reasons, we probably shouldn't share that photograph. Okay, Tora, so picking up this Liverpool City Council judgment that Ashley's been discussing, in your view, does this change the law on heritage assets in any way, or are we simply reiterating points about the contents of officer reports?
Yeah, Killian, I don't think it really takes us much further. It really is about the content of officers' reports. And in fact, at paragraph 11 of the judgment, Lord Justice Lindblom records that the appellant had conceded that there was no wider importance in the section 66(1) issue. That said, I'd absolutely agree with Ashley that it's taking us back to sort of normal service in terms of the importance of reporting consultee responses. But I think what this case does is, in marrying the section 66 issue with the officer's report issue, it makes clear just how much more careful one has to be when you're dealing with section 66(1) reporting to your committee, not least because of the NPPF requiring your understanding of significance, etc. There's a lot of information that the decision maker is required to understand. And so therefore the decision maker, who is the committee, needs to be apprised of the expert advice that they've been given. And here, you know, the omission of a consultation response, it doesn't really take a rocket scientist, I think, to understand why the court reached the conclusion that it did. And Lord Justice Lindblom said that this was an obviously material consideration, which simply wasn't mentioned in the report and therefore found the error of law. So I don't think it takes us much further, but it is an interesting commentary on the two areas: the duty to the section 66 duty, and also the law with regards to officers' reports.
Great. I can see from the chat function that we're joined by Hugh Richards, who's a very fine barrister from number 5, who said that it's the church that he was married in is his favourite heritage asset. So I think he's scoring brownie points there with his wife. Well, picking up the Liverpool City Council, one interesting feature of the case is in that judgment, the Court of Appeal said that they weren't willing to refuse to quash the decision on the basis that it wouldn't have made a difference, test. Matthew, what's your experience with when the courts are engaging with this question?
Well, I can think of one amazing example where my client's Dorset Council was saved by section 31(2)(a), and the whole makes no difference argument. It's a case called Adverse against Dorset Council. It came out a few months ago. And it was basically a case where an error of law that was identified in the officer's report in respect of applying the NPPF balancing exercise in paragraph 196, balancing the heritage harm and the public benefits. The officer's report just had slightly messed it up, hadn't quite got it right. And the court concluded that the outcome, i.e. the grant of planning permission, was highly likely to have taken place even if the error hadn't occurred. This was a case where the planning application in question mirrored a major strategic allocation in a recently adopted local plan. And so I don't think it's much of a surprise to see that Mr. Justice Swift found that the error made no difference, because one of the factors was that the heritage impact had been taken into account at the time when the site was allocated in the first place.
Well, Thea, for you, a question for you then. It would make no difference. So when we've got an established error of law, but the courts say, well, we're not going to quash the decision because it wouldn't have made a difference. Is that the law settled on that question in the context of heritage assets or not?
Well, I mean, in terms of the question of is it settled, it's a tricky one, because whether you're looking at the simplex test or whether you are looking at section 31(2)(a) of the Senior Courts Act, you're dealing with a judgment that the court has to make about, you know, would it have made a difference, as Matthew puts it. You know, the thresholds are expressed differently in both simplex and the statutory language, but essentially the court has to be satisfied that the decision would have been the same, or that it's very likely to have been the same. So it's a judgment, and it's for defendants really to raise this issue at an early stage in litigation and to put forward the points. It's not just enough to say, oh, well, it would have been the same. You have to explain why now Now, in Matthew's case, obviously it's allocated, it's been through that process of examination, someone has already considered these issues. So of course, not surprising at all that the court found that it wouldn't have made a difference but for the error of law. But there are also a huge number of cases where the court have come to the opposite conclusion, that they can't be satisfied, that had the error of law not been made, that members wouldn't have arrived at a different conclusion. Now, Mr. Justice Dove in Canterbury City Council gave some really helpful advice. That was in the context of a Section 288 challenge. So, of course, applying simplex rather than the Senior Courts Act. But what he said, and what's subsequently been adopted in judicial review challenges as well, the Legoland case, I don't know if you're aware of that, but essentially, at first it's for the decision taker to demonstrate that the decision reached would have inevitably been the same without the legal error. Secondly, that in exercising its discretion, the court must be careful to avoid trespassing into the forbidden territory of evaluating the substantive merits of the decision. So we know that, you know, the courts can't engage with the merits when they're looking at this particular issue, because ultimately the court isn't provided with all the material before the decision taker, so it doesn't have the same scope for consideration as the decision taker. And finally, the judgment must be reached on the basis of the facts and matters known at the time that the decision was being taken. So it's very much up for grabs, particularly, I mean, funnily enough, thank you to Matthew for adverts, because I had a case that was challenged. I was acting for the developer. They had a site that was allocated in a recently adopted plan, and the examiner had regard to the heritage issues when finding the allocation sound, and that was challenged on the basis of heritage harm. Unfortunately, the outcome was the same as in Matthew's case, although by a slightly different route. We didn't have to rely on discretion. So there you go. So not settled, very fact specific, a judgment to be made in all cases, but certainly if you're defending it, then get those arguments together and in very early on in the process of defending a claim.
Thanks, Thea. So just to finish off, we've been asked a question by Jenny Turner. And Jenny asks, paragraph 196 of the NPPF allows for public benefits to be used in the planning balance, but she asks, well, why does paragraph 197 dealing with non-designated heritage assets not do the same? And perhaps what I'll do is I'll share my screen so that we can all see these relevant paragraphs of the NPPF. And then Matthew, do you perhaps want to have a stab at answering Jenny's question? Absolutely, yeah. So it's a good question. There is no express reference to there being a balance in 197, but I think the answer is that even with non-designated heritage assets, you can take into account the public benefits of the scheme. And I think that's implicit in 197 by the fact that it references weighing applications that directly or indirectly affect non-designated heritage assets. So it's sort of implicitly saying, well, weighing against what? You must be weighing it against the benefits. It can't be anything else. And it's worth pointing out that there's quite an important difference between 196 and 197 when it comes to paragraph 11D and whether there is a policy in the NPPF which provides a clear reason for refusal, which could take you outside of the tilted balance. Because if you look in footnote 6, it looks like Killian with his fast fingers is going to get it up. But if you look at footnote 6 to the NPPF, you'll see that the list of policies that can provide a clear reason for refusal only says designated heritage assets. And then there's a sort of minor caveat to that in terms of other heritage assets. But it expressly doesn't apply to non-designated heritage assets. So that's one important distinction to bear in mind. I sort of felt like your assistant there, Matthew, sort of highlighting words as you go. I love that. I really need someone like that in court. Right. Well, thank you very much, everyone, for joining us. I hope that was a whistle-stop tour of what's new with heritage assets, and I hope you enjoyed yourselves and took something away from it. We're now going to take a bit of a break for the summer, so we won't be with you next Tuesday, but we'll be back with you hopefully in September. And we don't know what will have happened between now and then, so we don't know what the subject will be, but we'll, of course, advertise in due course. And thank you very, very much, everyone, for joining us.